And we're live. Hello, this is Attorney Matthew Newsom with Surge Business Law for our second April Ask Me Anything. We have about 10 questions, a lot of them more technical, open source, business, and such like that, but a good mix of other non-technical questions as well. As usual, I am an attorney, but I am not your attorney, so please use caution when accepting or following advice that you find on the internet. It's always better to talk to a professional because specific details about your situation could affect the results. I'm always eager to get your questions. Feel free to drop them in the chat or in the comments, and I will get them and add them to future Ask Me Anythings. And that way we make sure that everyone's questions get answered. But we've got a pretty good mix for today's, so let's begin. First one, this was a very interesting and lengthy one. What challenges do mobile app creators face pre and post launch? And this is a question that I'm very well suited for because before I was an attorney, I was an engineering manager for a software development company. I worked on self-driving vehicles and other technology related products. And before that, I was a software developer. So I'm very integrally familiar with the three different kinds of challenges you face when you are getting ready to publish a mobile or even a non-mobile application to the internet. I say three different kinds of issues. So we have business issues, technical issues, and legal issues. And that is one thing that makes Surge Business Law different is that when you ask us for help, you get business knowledge, technical knowledge, and legal knowledge from our team. But some of the business issues that I came up with were, first of all, keeping your costs in check. This is a very serious issue that companies face when they are developing products. And this is something that we see even in the home building and services market is that sometimes costs can get out of control. And oftentimes that's because you're hiring developers, you're hiring designers, maybe you're hiring contractors to help you create this product. And it's very hard to predict how much it's going to cost and how long it's going to take. And the second big risk is about the length of time. And so you might have deadlines, you might have leadership on the team who say, we want this out by such and such a date. And it can be very easy to underestimate how complicated it is to solve these problems and how long they're going to take. And so oftentimes what we like to do is instead of planning things far, far out, we like to plan phases where we do work in small chunks. And that way we can better predict how long it's going to take to do things. But the fact is that deadlines are missed all of the time. I would probably say every single day, some tech team is missing their deadline. In addition to that, then you run into other problems that happen after launch. A big business issue that companies face when they're releasing a product is getting users to use their app. And there's that baseball movie, Field of Dreams, where the person says, if you build it, they will come. And so that's not true when you create technical products. It's not guaranteed that having a really good idea means that people are just going to climb all over themselves to use it. And so you have to have a plan for how you're going to get people in there. Ideally, that is something that you start before you work on the product, that you line up an audience of people who you think need the product and are consulting with you and saying, make it this way so that we can use it. And that way you've got people ready to use the app and hopefully ready to brag about it to social media and to business colleagues so that more people use it. And so then getting them to use the app that you make is a big deal. Getting them to pay for the app is a very big deal. And so when you want someone to pay you, it's a little bit different story. Like getting people to use a free app, that's tricky. That's tricky. If you've ever released a product, getting people to use it is a bit of a milestone. If you want them to pay as well, you're probably going to need to have some good salespeople working throughout this process to get them signed up. Technical problems. I just listed a couple. There's so many, but I stuck with ones that have some kind of connection with the legal and business world. But first of all is secure by design and privacy or private by design. These are two concepts, and I'll just say this, a lot of people don't really know exactly what that means, but usually you can figure it out from the name. But a lot of times people, they create a product just by kind of playing around with something. And it's kind of like having a big blob of clay and you kind of shape it. You're like, oh, it's starting to look like a bowl. Then they say, okay, I think we can turn this into a product and release it. That's fine. A lot of great products started that way. But a better way is to start with a concept called secure by design and another concept, privacy by design. And what this means is from the very beginning, you are thinking about, okay, what kinds of data is going to be in this app, and do we have risks related to security or privacy with that data? And then, okay, now we're going to build the admin screens. How do we address those security and privacy risks? How are we going to share this to the public? Are people going to log in? And that kind of stuff. And so when you do secure by design and private by design, then all of these other things that you layer on top kind of inherit that secure and private concept. If you try to bolt on security later, you're going to be chasing your tail forever. If you try to bolt on privacy later, you're going to probably rewrite major parts of the app. That is okay. It's not the best, but it is okay. I want you to know that people rewrite apps all of the time, and it is usually a necessary part. And I just want to be clear, it is usually a necessary part of the process. But the less we have to rewrite, the better. And so secure by design, private by design are good concepts. Google them. Let's see. Quality issues. There's this conversation going on, is AI going to replace software developers? And I think that the answer is it's going to replace some software developers. But if you've ever played with AI or if you've listened to the news, you've heard of these really interesting failures where AI said something completely wrong or did something completely wrong. And if you're a software developer, you've probably played, okay, how can I make Copilot write code for me, or ChatGPT write code for me? It's fun. You can do a lot of things, but you can spot errors. And so, but don't worry, humans do this too. Humans and AI both make errors when they write code. Quality is an important concept. And so, do you have tests? Are you automating your tests? Do you have certain standards? What are you going to do if somebody reports a problem? I think quality is a very important technical issue. And again, it's better if you think about it at the beginning rather than at the end. And then the last thing is capacity planning. And this is one that I actually do support doing at a later time, because a lot of people, they try to over-engineer their product to build in all of the worst case scenarios at the beginning, and then you end up with an over-engineered product. I'll tell you what, the biggest problem companies have at the beginning is not too many users, it's too few users. And so you can reduce performance bottlenecks as they appear, usually pretty cheaply. Privacy, not so cheap to add on later. Scalability, some things better to do up front, but a lot of them you can do later. Now let's talk about legal issues. Again, privacy by design, security by design. Privacy laws are strengthening across the world. And so in Europe, in Brazil, in Asia, we're seeing a lot of new privacy laws. In America, the privacy laws have always been kind of separate. You've had HIPAA, you've had COPPA. These are all privacy laws that work in different areas. And so they overlap and touch in some places. CCPA, there's other things. You should probably be up to speed and thinking about those issues. You also want to know, like, what am I going to have to put into my app in order to attract the right kinds of customers? If you are doing a B2B app, then you're probably going to have to plan for one day offering SLAs. SLAs are service level agreements, and it's a contractual agreement that says, I guarantee that we will not have more than 15 minutes of downtime a month, or something along those lines. Or we guarantee that our backups are done every day, or whatever it is. You're probably going to have SLAs. And so do think a little bit about what your customers are going to expect from you so that you can start that as early in the process as possible. Again, don't over-engineer. I just want you to say, one day we're going to need this. And so let's just keep it, on my to-do list for one of those days. PCI compliance. If you take payments in any way, really, you're going to need to just look into PCI compliance. That is Payment Card Industry Standards, if I remember right. This is a right acronym, but essentially it makes sure that payment information going through your app is handled securely. And it can be very comprehensive. It might even involve someone auditing your office, your physical office space, to make sure that you're not keeping paper records out on desks and such. PCI compliance can be a very big deal. And it's one of those things that if you do it right, can be an awesome boost for your business. And if you do it wrong, can be a terrible lawsuit. How about accessibility compliance? This is increasingly important for certain industries, but it is also good for all industries. Is can people who have vision problems, color blindness, auditory problems, palsy, all these different things, can they use your tools in a way that is necessary for them or is useful for them? You also need to make sure, and this is going to be a big topic for later questions in today's live stream, but are you using properly licensed software? So if you have purchased a license to use the software, have you purchased the right numbers of license? Have you purchased the correct license? This is a challenge that you do have to do, and you want to plan for this early on. The good news is that usually small companies who are just launching a product typically can float under the radar. But I will tell you that having worked for a large corporation before in their mergers and acquisitions team, it will catch up with you. So you're going to need to get that straightened out. And I strongly suggest your company create a policy of supporting intellectual property of others properly. What about open source software licenses? If you're using those, you have to make sure that you're using them in a way that complies with it. Open source doesn't mean you can do anything. Open source means that here's the terms that you have to agree to, and if you agree to these terms, then you can use it and according to the open source standards. What about terms of service? Do you need a terms of service in the app? And that is probably true. Some laws can protect you, the business owner or creator, if someone uses your app in an inappropriate way. And so a terms of service can help you. And so, we saw recently Tesla got sued because they sold full self-driving, and people were doing things like going to sleep. And so that is obviously against the terms of service. And when you bought the Tesla, you agreed you'd keep hands on the wheel and keep your eyes alert on the road. If you didn't do that, then that reduces Tesla's liability, hopefully. Privacy policies. If you have private by design practices, you should make sure that your privacy policy brags about that. But the reality is that every app nowadays relies on third parties in some form or another. And so your privacy policy is going to need to make it clear how your customers' data is used and stored and shared with those third parties. So if you use Amazon Web Service, guess what? Amazon has, in theory, access to that data because it's on their servers. And then another one that's been increasingly important is FTC disclosures, Federal Trade Commission. And so the way that this has reared its head recently is in creators not disclosing that they had a financial relationship with products that they recommend, that they were getting a commission or a kickback by recommending products. But there's other ways that you can get into trouble with the FTC. So there was a long 12-minute answer to this really small question. The rest of the questions are going to go quicker. But here's my suggestion. If you're creating a product, it is worth calling me and asking for help. I am here to help startups launch, grow, and succeed. That's my motto. And we can talk through some of these issues. I offer very affordable flat fee rates to make sure that my products and services are available to as many people as possible. So please reach out at surge.law. So can a company add a non-compete to an employment agreement at a later date? And this is a very interesting question. It's so interesting. I studied it in law school, and I've studied again numerous times. This is actually a common problem. And it is a fundamental issue with contract law. So if you want to have a valid contract, you need an offer, you need an acceptance, and you need some kind of exchange in value, which is called consideration. So for example, do you want to buy my car for $5,000? Yes, I'll buy your car for $5,000. All right, here's the car, here's the $5,000. That was a contract. Sometimes we will see contracts be considered invalid or void because there was not a consideration. For example, you want to buy my car? Yes, I want to buy your car. Nothing exchanged. All right, no consideration. And I don't know where that word came from. It's definitely not used in that way in modern English. But in contract law, consideration is a very, very important concept. And in employment law, it comes up. Sadly, there's 50 states and the District of Columbia in the United States. Guess what? There's probably 51 different interpretations of how this concept applies in this situation here. And so if you are already an employee of the company, can I offer you continued employment in exchange for signing a contract? And the answer is, good question. It depends on what state you're in. Some states say, no, that's not valid consideration. You have to exchange something. Well, I wasn't going to keep them on. I was going to fire them, but I decided to keep them if they sign this agreement. Is that consideration? Again, it's hard to say. And different states offer different suggestions on how to deal with this. And so it is a very, very specific and state-specific application. But I'll just tell you the problem, that companies will hire you, you'll work, and then a year later they'll say, hey, we want everybody to sign a non-compete. Here you go, non-compete. And then the employees feel like they have to sign it. And that non-compete agreement usually has a line that says, in exchange for continued employment, such and such employer agrees to do this. And is that valid consideration? Well, in Iowa, the last time this was really clearly heard was in the 1990s. And employment laws changed a lot since then. I mean, a lot, right? Me Too did not exist in the 90s. So I don't know if that 1990s law would still be interpreted the same in a recent case. And sadly, a lot of employment law cases never get in front of a judge. They're usually handled in mediation or arbitration. So it can be difficult to know how a local court would rule in these situations. I'll just tell you this, that if you want a contract to be valid, consider offering the employee something in exchange for signing it. And, this could be, hey, we're going to have a company party. You're invited. If you want in, sign the contract. And oh boy, that feels a little sleazy, but at least it makes that contract a little bit more enforceable because you said, here's something of value that you got in exchange. If you are being asked to sign a non-compete, I strongly suggest talking to an employment attorney. You can call me, but I will probably connect you with someone that I know, but do call me and I will do that. Because employment law can be a very, very tricky subject. And again, the laws are changing often and they vary from state to state significantly. Can I use ChatGPT to make legal documents? And if you want to learn more about this topic, would you please either hit the like or leave a comment, because I am very curious to know what my audience thinks of this. The answer to this question is, of course you can. I mean, ChatGPT can do a lot of things. Will it make good legal documents? I've seen it. I've seen it produce great documents. Will it make mistakes? I've seen it do that too. Will it be obvious mistakes? No. No, I've seen it make very subtle mistakes. I've played around with ChatGPT and Gemini and some of the other tools quite a bit. I think they're fun. They save me a lot of time. I will go into ChatGPT as an attorney and just say, hey, I'm an attorney. This question came up. What are some of the things to think about? And it'll come up with some things, usually things that I already know, but once in a while it'll suggest things and I'm like, oh, that's a good one. So I think it's a great tool. It definitely has made my job and life easier as an attorney, but using it, I've seen it make mistakes, and I think to myself, boy, I hope someone who doesn't know what they're doing isn't doing this, because it could be bad. So can you do it? And the answer is yes. Should you do it? And that is, I would suggest getting a legal mind, getting another set of eyes on these documents if they are important, because they can be quite damaging. Just like people are saying software developers are obsolete because of ChatGPT, I don't believe it. I think that we're still going to need people who have a mind for computer programming to look at the source code of these programs to make sure that the AIs are doing things properly. But I think that smart programmers are going to be more productive by using the AI tools. And I think that lawyers and doctors and accountants and all kinds of professionals are going to be more productive with these tools. But I do think that it's a good idea to have a human in the loop somewhere in there so that we can catch mistakes. Here's another AI question. If I use AI to generate source code, will it be open source? Excellent question. In fact, we're going to have several open source questions in this video. I'm super excited and I love open source software. I have since 1995 when I started using open source software. If you use AI to generate source code, it is not going to become open source software, probably. Is that a disclaimer or what? So first of all, if AI generates something, then in the US at least, the US does not grant non-humans copyright privileges, with the exception of corporations and such. So AI's machines cannot have copyright. And so that means that that material created by the AI will be what we call public domain. Nobody owns it. Now that is like open source, but the open source definition is a little bit different than public domain. Public domain is actually more permissive. But here's the thing, if I use open source software, usually there is a license agreement. Somebody has a copyright to that software, and that license agreement puts some kind of burden on me, usually to give credit where credit is due or something along those lines. Public domain software, public domain material simply means it can be used without really any restrictions. And so it does have a little bit different connotation. Most people would say public domain software and open source software are fine, right? Public domain is open source. However, it does have a special meaning. It means that nobody has a claim to that software. But open source software is oftentimes used to train the AIs because there's so many millions of lines of open source software out there. And every once in a while, we will see the AI regurgitate software that it learned about. And you can go and search YouTube and other places for examples of people tricking the AIs to doing this on purpose, and it's not that hard. And there is a famous piece of software called Quake, a video game, and in that video game there is a certain famous source code comment where the person who wrote the software was really mad at the code and used a little bit of profanity. And so people have gone into the different AI tools and said, write code, and they trick it into spitting out that exact bit of code from the Quake source code. So what does that mean? Well, that means that this output now is actually a derivative work. It includes some software that has got a public domain license to it and some software that has a copyright attached to it, which might come with some open source requirements. So you have to be careful about using AI to generate source code. That said, there are some companies, and I'm sorry, I can't remember who create tools for developers, and they provide an indemnification clause that says if somebody comes after you, they will protect you. So if you're buying commercial tools that use AI to generate software for you and your software development team, look to see if there's an indemnification that protects your business in case of a lawsuit for something along those lines. That can be very helpful. But no, it's not going to be open source. Otherwise, it's going to be public domain. Can I sell open source software? Yes, you can sell open source software. In fact, one of the definitions of open source software is that you get these certain rights and freedoms, including the right to sell it. If you say, I'm going to let you have the source code, but you can't use it for commercial purposes, then you've put a restriction on there that no longer makes it fully open or open source anymore. And so, for example, there are source available licenses like the BSL. And so these licenses make it so that you can look at the source code and you can even use it and play with it, but you can't sell it or create derivative products of it. And so that is not truly open source software. Truly open source software does not put a commercial use restriction on it. And so, yes, you can sell it. However, you cannot exclusively sell it because other people can download that software and sell it too. Some software licenses do say that they explicitly permit you to sell it for a nominal fee in order to recoup the cost of packaging or whatever, and that's it. And so, that might be valid for the software that you're using. But generally speaking, yes, you can download open source software, change it, sell it. However, you need to understand the license. Open source software is licensed to you. That means the copyright creator gave you permission to use it, and they put rules on it. And those rules could include telling people where you got the software. Those rules could be including if you add something to it, then your additions have to also be open source. And so you can sell it, but you might have some requirements to go along with it. So it's a pretty easy answer. Yes, just make sure you read the license agreement. How does open source software affect my company if it's acquired? So I worked on a team that was integral to the mergers and acquisition process, where we reviewed the software that the companies that my employer was working on, that was acquiring, used. And so we would run tests to see, okay, is the software licensed in a way that's compatible with the acquiring company's uh, internal guidelines? And so the answer is that if you're being acquired by a company that doesn't like open source software, then yes, they might say, we're not going to acquire you, and because we don't want your open source software. That's becoming an uncommon position. Most companies do accept open source software in some form, but we have seen companies take hardline stances against open source software. More commonly, what we'll see is some companies say, these licenses, the Apache license, the MIT license, the BSD license, certain licenses are okay, certain licenses are not okay, like the AGPL or GPL v3. And so they'll look at your source code and say, are you using any software that is against our guidelines for use? If so, you have to get rid of it. Another situation is because a lot of people confuse open source software with source available software. And so they'll use something like, Redis is in the news recently for changing their license to be a source available license, but is no longer an open source license. If you use software like that, then you might have to buy a license before you can be acquired. And so we've seen that happen where companies, it's like 2 days before closing, and the due diligence review comes back and they say, okay, you got to go buy a license for this. It's 50 grand. We can't close unless you do it. And then the founders of the company being acquired have to go negotiate a deal with a commercial software company to have a compatible license. It happens. It stinks. And so what's better is if you are beginning the process of looking to be acquired, hire my firm, Surge Business Law, to help you do an analysis of your open source software to make sure that you're compliant. It's not going to throw a wrench in the gears of your acquisition process. Fixing this can take months, maybe longer. And so start early. Okay, open source software is a great thing. I love it, but making sure that you're compliant can be easy and it can be hard. And so talk to me and we'll help you. Can my company get sued if there is a security problem with open source software that I use? Yes, it can. And here's how it happens. So first of all, if you provide a service to businesses and those businesses rely on your product, then you probably have some kind of contract. And you might not have a contract that's specific, but you might have made a promise that constitutes a warranty. And so if your clients or customers are using your product and they suffer a loss because of software that you use, you are probably on the hook. Okay, here's the situation. You provide computer vision software to a company and they are doing inspections on products and the vision software works really good. Then there's a security problem with an open source component to your software, and then it causes a failure with your customer because products that were defective didn't get captured by the vision software that you deployed to them. Your company didn't write that bit of the code, but you provide a valuable service to your customer. They pay you to make sure it works. It doesn't work, you're on the hook. And so if they lost $100,000 worth of damages, guess what? You're probably going to be responsible for some or all of that cost, even if you're using open source software. So this is an important part of your business. If your business model includes selling software services that you don't have full control over, you are going to want to charge more to compensate you for that risk, so that if there is a problem, then you can afford to hire somebody to help you. Or better, that you can hire someone to help you before there's a problem. And this is in fact how a lot of open source software is funded, is companies who rely on an important open source component will hire a developer to make contributions to that product to make sure that the hiring company's business interests are met. And so there was a problem that was disclosed just recently called the XZ vulnerability, where a lot of companies use a software called XZ, and and it had a security vulnerability in it. And so it was caught because a company who used the XZ library hired a developer to monitor and manage how the company used this XZ library. And that person spotted the problem, reported it back to the open source company, I'm sorry, the open source developers, and said, hey, we found an issue, and it was fixed. But it was such a serious issue because many thousands of companies who also use that software didn't know about it. So that was a very interesting security vulnerability. You can avoid being a casualty in a situation like this by having someone looking out for your interests. And that's exactly what I do for my clients. So please reach out. Do I have to tell people that I'm using open source software in my product? And the answer is maybe. There are different kinds of open source licenses, and we sometimes classify them by how much of a burden they place on you when you use open source software. So some software includes a large burden, a large obligation on you to not only to basically make your own software open source as well. And so that's why some companies don't like the AGPL or the GPL v3 or even some of the other GPL licenses, because they don't want that additional burden. There are other licenses that have much lower restrictions. And there's a lot of really great software that's released under the Apache 2.0 license, the BSD license, the MIT license, such as these, because the only burden is that you must notify your users that you are using this open source software. And so, for example, one of my favorite examples is the Instagram app. If you go into the Instagram and you go to the About screen, you'll see way down at the bottom, it says software licenses. You click it and you can see all of the open source software components that Instagram uses to make their app. And it's cool because they followed the rules. And I happen to know some of the people who work on or have worked on the open source team at Instagram, and they care about doing things right. And so that's why I use it as an example. And your company should probably look and see how Instagram did it and Meta's other products, and model that, because it can be a very good professional way to not only do your duty, but to also promote the use of open source in the business setting in good, positive ways. So you probably do have to tell people that you're using open source software. There are some licenses that have no restrictions. They basically say do whatever you want. And it's a relatively small percentage of licenses. Some such licenses are actually unenforceable and null in certain countries, because some countries do not permit authors to give up everything like these licenses allow. So usually the notice licenses, like the Apache 2, like the MIT, like the BSD license, are the more common solutions, and they do put a burden on you. All right. How do I legally make food at home and sell it at a farmer's market? And this was such an interesting question. You guys are probably tired of hearing about open source software and copyright and stuff like that. So here's a little break for you. And so first of all, I have helped clients do this. So this was mentioned by Jen Wetzel, and she said, please tell people my name. I'd like people to know that I'm asking. Jen, so Jen, the answers to your questions are, first of all, you need to make sure that you have the right licenses and permissions to do food in your house. And so some products do require you to have a commercial kitchen. And so that's why some of these pop-up kitchens, or these kitchens that you can rent by the hour, are so nice, is because instead of trying to have a commercial quality kitchen in your house, you can just for a couple hours a week use someone else's. Not all products require that level of standard. So for example, products that are not made for human consumption might not have such strict requirements. You might need to be SafeServe compliant, which requires taking a class and then getting an inspection and having a certification given to you. This is extremely common. People do this all of the time. You can look up SafeServe and get the instructions on how to do that in your area. Zoning laws. And so, believe it or not, some things are simply not permitted to be done in residential neighborhoods. And if you live in an HOA, your HOA might provide additional requirements that restrict what you can do. Typically, these requirements are not going to prevent you from having a kitchen in your house that meets commercial standards, and it's probably not going to prevent you from cooking 100 oatmeal cookies a day. But if you have people coming to and from your house to pick up and drop off stuff, then they might apply to you. And so that can be an issue. So look to see if there are any zoning or HOA requirements. And then we get into probably the more serious ones. You're going to want to check to make sure that there are no health and safety standards that apply to your business, or if there are some, that you comply with them. And these can be at the local level. So for example, your city, county, or state might have health requirements that you have to comply with. And then the FDA may also have federal requirements that you have to comply with. And I've had good luck talking to the local certification places and just asking them for advice. I would suggest phrasing your questions like this. Don't say, yeah, I'm making food in my kitchen and selling it at farmer's market. Don't do that, because then they're automatically going to say, oh, well, we'll send an inspector right over. No, instead say, I am thinking about doing this, and I'm curious what rules are that apply. And if you talk to the local person, they'll be most familiar with the local rules, but they'll probably also know rules at a state level that you might also have to comply with. Or they might at least have a reference for where on the internet you can go to find those state rules. And then likewise, some industries are also subject to federal FDA and other such requirements. The next thing on my list, the last thing on my list, and this is not a comprehensive list, is labeling requirements. This is something that is becoming increasingly common and important. And so this is often regulated by the Department of Agriculture. And so they might have requirements for you to have a label that says how many calories or what allergens might be in your food. And so this is especially true for packaged food. So you're going to need to check with the Department of Agriculture. I have helped some small kitchen type businesses work with the FDA, with the Department of Agriculture. I found the Department of Ag to be very easy to work with. That doesn't mean they're lenient, but they're also very helpful, and they provide a lot of information on their website. So those are the things that I would start with. Also, you might need to check with your finance person, your accountant, to see if you have to do sales tax. Some things do have sales tax, some things don't. If you are wholesaling, then you can push that burden onto the retailer, and you can simply just sell to them at wholesale prices. If you are selling things or buying things tax-free and using them yourself, you might have to pay a use and consumption tax. Again, your tax person is the expert to talk to. And we're getting close to the end. Are loans paid off as part of an asset business purchase? And so, so let me just make this clear. When you are buying a business or selling a business, there's a couple different ways to do it. If you go to my website, surge.law, I've done a webinar on this. You can watch it. It's like 45 minutes long. It's very comprehensive. But there are asset purchases, which are usually the simplest and easiest and safest for buyers. There are basically what we call shareholder buyouts, where one person buys all of the shares of another existing business and takes over the business. That can be very handy in certain circumstances, but it does mean that you're not just getting the assets, you're getting the liabilities. Because of that, then a lot of companies think that it's safe to do an asset purchase, and that is only true to an extent. Asset purchases are safer because instead of just buying everything good and bad, instead you're picking and choosing. I want the domain name, I want the Google profile, I want the social media, I want the phone number, I want the hardware, I want the inventory. You create a menu of all the things that you want. That's good. However, if the seller has a loan, that loan might have attached a lien to some of those assets, and that lien can transfer when someone else buys it. So for example, let's say that you bought a skid steer for your construction business, you borrowed money, the bank attaches a lien to the skid steer. that can be very difficult to find because skid steers don't have titles like cars. So you don't have any way to go look at the title and see that it's clear. And so this is what we do when we help people buy or sell a business, is we do a check on the assets to see if there's any liens. And then what happens is if there are liens, then we usually do negotiate as part of the purchase agreement that the money is held in trust, just like you're buying a house. And then we use the money from that trust to pay off any liens that apply to the assets being purchased. And then the money that's left over goes to the seller so that they can cash out. And that is usually important. So the answer is, we do typically like to see loans paid off as part of an asset purchase, as an asset purchase business sale, but it's not required, only if the assets are encumbered with some kind of a lien. So I hope that helps. If you are buying a business, please, 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 I plead with you, talk to an attorney. I've seen so many sad stories. It works sometimes just fine, but so many times people come in and say, I'm getting sued, or I need to sue, or this is getting repossessed, or they just closed my bank account, because these things go wrong. And so we can help you avoid those problems. With that, we are done. So please hit the subscribe button, hit the like button. I want to make sure that you see these when we do the future ones. If you have questions, please leave a comment, and then we'll add them to the next AMA. This is Matthew Newsom, the attorney with Surge Business Law. I look forward to seeing you on future videos.